Hey folks, welcome back to the channel, or welcome to the channel if you're new here. Today, we've got a major story on deck. More lawfare from the left in their attempts to stop the Trump administration's progress. More on that in a moment. First, please subscribe to the channel. Let's take a look at the players in this story. The NAACP is first up. The NAACP is suing to stop Trump's executive order dismantling the Department of Education. Why? Good question, since they are not a group focused exclusively on education. The second player in the lawsuit is the NEA, or National Education Association, the U.S. teachers' trade union and largest union in the nation. The union expected to collect nearly $379 million in dues in fiscal year 2023. That's a big budget. And it appears education isn't necessarily their main focus or concern either. Trump signed an executive order instructing Education Secretary Linda McMahon to dismantle the federal agency as far as she legally can, according to a report by The Hill. The Trump administration wants to move the focus of public education back into the hands of states, allowing those closest to students to determine the best courses of action for students' educations. Makes sense, but there is one critical legal question that needs to be answered to fully understand how this lawsuit is moving forward. Do they have standing? For federal lawsuits to proceed, there must be standing. Standing in a federal lawsuit refers to the legal requirement that a party must meet in order to bring a case in court. It ensures that the plaintiff has a sufficient connection to and harm from the law or action being challenged. So what exactly is the injury the NEA and NAACP are claiming? And how is a federal judge allowing this to move forward absent standing? Those are the million-dollar questions. To put it into perspective, we only need to look back a few years to the 2020 election. This post by DC Drano sums it up well. The courts were quick to rule there was no standing by plaintiffs in those cases. That is just one example. We can also find examples during COVID where the requirement for standing was strongly enforced, and plaintiffs were quickly found to not have the required standing to move cases forward. Time and time again, we can see standing being a critical point in federal lawsuits. But now it appears to have fallen by the wayside. So what do you think? Are we watching a hypocritical double standard play out in front of our eyes in the federal courts? Leave your thoughts in the comments below. Remember folks, stay informed and always question the narrative. Thank you for watching 2 Minute News, your source for real, fast news.